Welcome to From Students to Licensed Professionals, Protecting Your Rights.
Welcome to From Students to Licensed Professionals, Protecting Your Rights with attorney James Kosnett. James has represented licensed professionals for decades, helping doctors, nurses, dentists, teachers, real estate professionals, and others protect their licenses, their reputation, and their careers when complaints or investigations arise. I'm Lisa Mosby, and today we're talking about why a licensing board investigator might contact you and what that could lead to. Welcome, James.
Hi, Lisa. Good to see you.
Thank you. James, why would a licensing board investigator contact a licensed professional in the first place?
Clients, patients, sometimes hospital directors or employers, people make complaints to a board about their licensees. Sometimes there's a reason for it. Sometimes it's just absolutely unfounded, but nevertheless, every complaint is received and processed and quite often investigated. So the first time you know that something's happening, you meaning the licensed professional, my potential client, I'm talking to you as if you are that person. The first time you find out about it is when an investigator contacts you. And how might they contact you? Well, they might send you an email and introduce themselves and ask you to give them a ring or send them an email to acknowledge their email. Or they could call you up on the phone, which is very common. And it's not unknown for them to show up at your office or even at your home or even at some place where you least expect it. Like you drive to the store and you're getting out of your car and then someone approaches you and they say they're an investigator from the board or from the Department of Consumer Affairs, and you have a second, answer a few questions. So it can be quite shocking and take you totally by surprise.
And what is the investigator trying to accomplish at that stage? And what have they likely already reviewed before reaching out to you?
They've likely reviewed the complaint of consumer, your client or your patient or your former whomever, and they've probably talked to them, gotten some more information, made some notes, and now they're going to try to get your reaction, your perspective. And anything you say can and will be used against you. So your first inclination might be, oh my God, yeah, I remember so what? No, I didn't do anything wrong. What are they saying? And no, I can tell you whatever you want to know. Your first inclination, especially if you feel very confident and that you've done nothing amiss, would be just to say, to try to show them that you've got nothing to hide, put your cards on the table, answer their questions, and you can get rid of this quickly without expense and without having to hire an attorney or without further worry. Nothing could be further from the truth.
And what are they expecting you to provide at that moment, at that initial contact?
They're expecting you to, or they're hoping that you're going to answer their questions and give them information that's right off the cuff that they can take down and use to put in their report. And that's what they're going to do. The professional, my client doesn't realize that you can't talk that investigator out of a case. That investigator's job isn't to evaluate the case and make a decision on who's right and wrong. That investigator's job is just to gather information. So you're not going to save yourself time and worry and money and increase your odds of a favorable outcome by some quick responses. What you've got to do is just to give them a smile, or on the phone, give them your sunny voice and say, oh, You caught me at a rough time right now. Can I please have your name and your contact information and I'll get back to you? They might push back. They might say, well, sure, but just answer a few questions right now because we got you right here. I'll just take a second of your time and we can save a lot of time later. Don't be fooled by that. Say, insist, no, no, I got to get going. This is not, but I will get back to you very soon. How soon? In a couple of days, I'll be back to you. Then you take down that information or you put it in your phone, whatever it is, however you record things these days, and you call me or you call an attorney to help you. And we will get in touch with that investigator and we will find out what's this about? Who made a complaint? What's the nature of this? How long has this been going on? And I would advise you pull up your records on this person once we find out who the complainant is. See what you've charged him or her. See when they started with you. Is it ongoing? Is it over with? How long? What was the outcome? Let's look at the emails. Let's look at everything. Let's have it in front of us. Gather the materials. Share it with me. And let me advise you as to what happened, what you did, what they're claiming you did, and so forth.
So, James, what changes once communication with the investigator is handled through an attorney?
Well, for one thing, you're protected. If Let me just give you a crazy kind of example. If you told the investigator, "Oh yeah, I saw that person in 2024," and you didn't see them in 2024, you saw them in 2023. Okay, right away it looks like you're off by a year, doesn't it? It looks like you've already got some facts confused and you're not too sharp. But let's say I gave the wrong year. Well, I just got confused. I've only got 100 cases, right? So, oh no, that was my mistake. My bad. Did I say 24? I meant to say 2023. But they can't hold that against you. So one thing, there's a buffer now between you and your board, myself, and they're not going to hold what I say against you. Okay, that's one thing. Another thing is that I'm going to be very careful what I give them. I'm going to make sure that I'm not going to give them anything that could hurt you. Does that mean I will not be truthful? No. But there's a difference between saying something that's false or just not saying something in a certain category or to a certain issue or topic. So I will not give them anything that is going to hurt you. And I'm going to be very careful what I reveal. I'm going to learn more. It's interesting. If a person wants information out of you and they're asking you questions, sometimes you can get a lot more information out of them than they're going to get out of you. It's funny. The person that's looking for information will often give or have to give a lot of information on themselves if they're asked, if they're pressed for it. And so this is what I always do. Then, under the government code, I'm typically entitled to a copy of the file or at least a summary of what is in that file. So I will always ask for that. I will always ask for that. And I will share that with my client and we'll discuss it. Then I'm going to see how, working with my client, I'm going to see how we want to handle it. If we feel that summary is sufficient, then we might be ready to cooperate to some extent with the investigator. If I feel that this cooperation is going to help my client, we'll talk about what he or she is going to say and we'll be on the same page and we'll get it straight. And then we'll tell the investigator that, yes, they can go ahead and schedule an interview with my client and so forth. But if for some reason we don't want to submit to an interview, then I'll always ask for the full file. Sometimes I won't get it. They just don't want to give it. But then they they might not be able to get the interview. So it might put off the interview or avoid it altogether. Sometimes they'll give us the file. Now we have more information to work with. Sometimes they won't give us the file, but they'll still want to have their interview. They'll insist, no, the summary I gave you is sufficient, and now you must submit to an interview, or your client must submit to an interview. Before we get to the formal action, while we're still on the investigation stage, if the investigator wants to push it forward and I'm not cooperating with him or her, he or she might decide, or the attorney in charge of the case behind the scenes may decide to go to a court and get a subpoena or an order. First, they might issue an agency subpoena, and then if we don't comply with that, they may get a court order or seek a court order. Well, to do that, I'm entitled to respond to the judge and say, Judge, I didn't say I wouldn't sit for an interview. I said I wanted to see the full file, and they're not showing it to me. The judge might well order them to do so. That's to our advantage. And if the judge disagrees with me, there's no harm. The judge might say, no, Mr. Kosnett, I think the summary they gave you is adequate, and I want you to proceed. I'm ordering you to comply with their request for an interview. Fine, Your Honor, then we'll do it. But that's not necessarily the end of it either, because the client still has his or her Fifth Amendment privilege if the questions relate to areas which, if answered, could result in a criminal prosecution. The client is totally justified in taking the Fifth Amendment and not answering those questions. And I discuss with the client whether we should use that strategy or not. It's a very powerful strategy.
So, James, what influences whether an investigation escalates into a formal action and what does that formal action look like?
Well, at some point in time, the investigator is going to close his or her report and just submit everything back to the attorney in charge or to the board official who's going to make that decision together with their attorney. It could be a staff attorney, such as in the case of the Department of Insurance. It could be a deputy at the Attorney General's office, such as in the case of the Medical Board of California or the Board of Registered Nursing. And they will often be cautious and err on the side of seeking discipline of the person's license. Not always. A lot of times my involvement and my pushing back, and depending on what the facts of the case are, may influence them to back burner it or not even go forward with it. But quite often they will. And if they do decide to go forward, they create a pleading that's entitled accusation. And that's like a complaint in a court of law. And the accusation will recite the facts as alleged by the complainant and as found by the investigator and seek various discipline. And the discipline against the licensee could range anywhere from the worst case, revocation of the license, to, in descending order, a suspension for a period of time of that license, a period of probation, where that license is restricted and it's under probation, under various terms and conditions that can vary greatly, or what's called a public reproval, which is kind of a public finger wagging or scolding that's on the record. It's on the internet, and it stays on your record, sometimes forever, sometimes for a given number of years. It depends on the particular board that you're governed by.
So, James, what happens after they file the accusation?
They will serve that accusation on the most recent address they have for you with your board. So it's very important that you always stay current and keep the board current. It's not enough just to have a post office forward things. That's not a good idea because that's imperfect. We all know how that fails all the time. And if you don't get it, they will proceed against you in your absence and get a default. And then, can I get that default set aside when you eventually find out about it? Yes, but it costs time and money. And after we're successful, we're still back to square one and we have to deal with it. So we want to avoid that happening. So you'll stay current if you're wise with your address, with your board, and then you will get it promptly. And you will have certain number of days. Usually it's 15 days, sometimes it's 20. It varies board to board in order to request a hearing. That's the same. It's another way of saying I disagree with this action and I want to challenge it. So you request a hearing, you file what's called a notice of defense. A licensed person can file that notice of defense on their own and go out and look for an attorney. And that's what they should do if time is running out with their 15 days. But if they have time and they come to me in time, for example, and they retain my services, I'll do that for them. They won't have to do it. But one of us will get in that notice of defense in a timely fashion. That's the first step to stopping this from resulting in an immediate bad result. Okay. Now there's a discovery that happens on both sides. And what is discovery? It's a sharing of information, documents, photographs, names of witnesses, recordings, anything that bears on the allegations in the case. And we share our file. Usually discovery in the administrative context is much more efficient, wastes a lot less time, and is a lot less expensive than in a civil court of law. It just is. It's you, because if we don't share information with our opponent, we can't use it when it comes to trial. They'll object to it. They'll say, I never saw that. And then we'll be deprived of it. I don't want that to happen. So I make sure to share anything I want to use with my opponent. And of course, I'll go over everything my opponent shares with me, with my client. Then we'll have an opportunity to settle the case, work out a compromise on either something very light, some light kind of discipline, or once in a while, I can even convince them to drop it entirely. About half the cases that I handle do settle. If we don't settle, that's okay. We'll go to a hearing at the Office of Administrative Hearings in front of an administrative law judge.
James, I think that's where we'll leave it today. This has been very enlightening and detailed, and I appreciate your insights today.
You bet. Good talking with you again.
That's it for today's episode of From Students to Licensed Professionals Protecting Your Rights with James Kosnett. If you've been contacted by a licensing board or are dealing with an investigation, visit professionallicensedefense.org to learn more and schedule a free consultation. Thanks for listening, and don't forget to subscribe, share, and leave a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.